All right, this is this year's edition of Stump the Underwriter. We've never done it quite this way before, and I hope I can talk in this mustache. So, and I hope more than that, these guys can talk in this mustache. So, a couple of preliminaries before we begin. We've been doing this a number of years, and I keep thinking we're going to run out of questions, but they keep coming in. The questions all this year are inspired by real life, either Tennessee cases or situations that have come up in actual practice. And so I don't say they're the exact facts. Some have been modified to meet the needs of the program, but they're all inspired by real life. So hopefully you'll see that as we go through. Also, our underwriters. We got the finest underwriters anywhere, I think, in the state of Tennessee. I'm always glad to be able to get them all in one room and just kind of see how it goes every year. And the other thing you need to know, people think that they have seen the questions before. What are you laughing about? People think they have seen the questions. They have not seen the questions. Only 2 people in the world have seen these questions, my assistant and myself. So this is all cold, and they do a phenomenal job. So let's give them a hand before we get started. And let's also identify yourself. Mark, just quickly go down. We'll go around the list and say who you are and who you underwrite for.
Mark Rosser, First American.
Mike Davis, Old Republic.
Mike Bates, North American.
Stuart Jones, Fidelity National Title.
Justin Tanner, Agents National Title.
Tom McCroskey, West Corps.
All right, let's get going. First question. White Oak Partners is purchasing a commercial lot in Morristown. The only access to a public road is by an easement over the neighboring property. The title examination shows that when the easement was granted, the neighboring property was subject to a deed of trust held by Mountain Bank and Trust, which was later foreclosed. Will you insure the transfer, and why or why not? So, Mark, we're going to start on the right, and you will take the first shot.
Okay. Neighboring property was subject to a deed of trust held by Mountain Bank and Trust, which was later foreclosed. The easement was granted. The neighboring property was okay. I'm looking for some indication that the foreclosing bank had subordinated its interest to the easement, or joined in the easement, or granted the easement. If I can't find that, then I'm going to want the bank or whoever that bought the property from the bank to grant or re-grant an easement.
Okay, so are you going to insure it?
Well, I'm not going to insure the easement until I get an indication that either the bank has joined it, whoever the fee owner now is re-granted or joined in the easement.
Mike?
Same position. I mean, if foreclosure wiped out the easement, I don't have access to that property. That's the only access. So unless I can get that easement reinstated, or unless it was subordinated prior to foreclosure didn't wipe it out, I'm not going to be able to insure it either.
Same thing here. The question is, will you insure the transfer? The answer is yes. This is what are the requirements and what are the exceptions in order to insure it?
Okay, Stuart.
Yeah, I mean, I would insure the transfer, but if the easement was subordinate to the deed of trust, it's been wiped out. So if they don't grant a new easement, I will take exception for the lack of access.
Okay.
That or require a hearing for, prescriptive easement or something like that shows that there's access to it order.
I'd be crazy to do anything different now.
Well, we have consensus, and you all are in agreement with Court of Appeals of the Eastern Section. The case of Helmboldt versus Jugan, July of last year held the same thing. That basically this easement was wiped out by foreclosure. So it was something that burdened the property, devalued the property, therefore it was wiped out. And so, excellent, good job. Do we have any dispute on that one? So let's go on.
Oh, yeah, that, absolutely, yeah.
That's what you'd want to do. You know,
Right.
exactly. You gotta search the adjoining parcel too. So, all right, have consensus on that. So you know what to do if you see that in the state of Tennessee. Next question. Country music rising star Chelsea Morgan is buying 19 plus acres in Wilson County. The contract of sale calls for the legal description to read as follows. Tract 1 on the subsurface sewage system location map of record in Plat Book 62, page 102, Registrar's Office for Wilson County, Tennessee. Will you ensure this description? Why or why not? Let's go to the next slide and actually see it. Well, that's kind of like examining the title. You can't hardly see it. But that's actually a copy of the map. You can see that. So I'm going to put it back on the question there. And I guess, Mike, we're going to start with you this time.
Well, I can see that pretty well. If it's a description by reference. No different from referring to any other plat. Now, if I've got a good meets and bounds on there, a good description that I can follow on that drawing, and I'm referring to that, and then I could use it. But it all depends on what's on that drawing, whether that drawing is adequate enough to give me a description that's going to be insurable. Because
You want to see the drawing back up? Can you see it good enough?
yeah, track 1.
It's a survey.
Yeah.
No question about that.
So it's a description by reference. What's the difference in any other plat? It may not be a plat that's been approved by the planning commission, but it's still of record. It's a description by reference, so I can refer back to that and I can ensure that.
So that would be an adequate description.
That would be.
Okay. What do you think? Sure.
Again, I go along with Mike. I mean, it's over 5 acres, so that's not an issue. If there's adequate needs, I can't see it either from here, but if there's an adequate description on there, then it's incorporation by reference. But here's the question not asked. Are we going to have exceptions to matters of survey, the standard survey exceptions? And the answer to that is yes, that we'll have those survey exceptions because it's a 19-acre tract, and we probably say, well, we need to have exceptions, or we need to have a up-to-date current survey.
So you would insure it with proper survey exceptions.
Correct.
Stuart. Give it the mic.
I would take a slightly different view. I think since it doesn't appear to be an official plat, it's just a survey, and although it does have calls on there, I think I would require them to get a surveyor to go out there and give me a meets and bounds based on that. And I think for purposes of a legal conveyance, I think that would work, but I have a problem with it in terms of insuring. So there's a difference between what's legally good and what we need for title insurance purposes.
Okay, would you insure it if it was a meets and bounds description?
Yes.
Okay. Justin.
Yeah, I agree. If there's a meets and bounds description, I just think of the land records, going back in time and going forward. First of all, it's highly irregular. You don't hardly ever see a lot reference back to a sewage plat. I don't, at least anyway. So I agree. I would probably require a new do meets and bounds if there's not something on there already.
Well, I was gonna say no when we were just looking at the question, and it just had that reference, but then I think I'm more like Mike and Mike here. When I see that, I start looking closely at that. It looks good from here, but also with Mike Bates, definitely the standard survey, exclusions, exceptions for that. If they want survey coverage, they have to do survey.
So you would insure it by reference to the plat with survey exception?
Yeah. It looks good enough to me. I mean, not being able to go over it real closely, but.
Mark, you're last up.
Yeah, this one's, like a lot of these questions are, I don't want to say screwball.
Don't insult the host.
I think the salvation on this one is the amount of acreage. I would require meets and bounds description. As an aside, I had this come up not long ago on one that was less than 5 acres that I turned down, only to find out that First American had already insured it without me being asked about it, because the subsurface plat itself is pretty much worthless for legal description purposes. But if you do a meets and bounds description, and because of the acreage involved, I mean, if that fits the deeds and the chain of title and so forth, I think you could come off of that. But I would not refer just to the subsurface plat.
Okay, so you'd have a meets and bounds description.
Yes.
Survey description. Yes. Oh, great answers. Well, let me refer you to Tennessee Code Annotated, Section 13.3.410, which is our Regional Planning Commission statute, which says this: the owner or the agent of the owner of any land shall not transfer, sell, agree to sell, or negotiate to sell the land by reference to, exhibition of, or by other use of a subdivision plat without first submitting a final subdivision plat to the Regional Planning Commission and receiving the Commission's approval, and before the final plat is recorded in the appropriate registrar's office. So that's, I think, consistent with what most of you said, and but it is more than 5 acres. So, but I think we see these, you've got this Planning Commission statute. Kind of go back to and look at that. It says what it says. Well, they took that out last year. They took the criminal penalty out, so you just got civil violations.
How does that affect whether you still insure it?
Yeah, what's the sanction for violation?
Well, we hadn't gotten that far.
Okay.
Next question.
This is Stump the Underwriter, not Stump the Moderator. It's TCA 13.3.410, and that's the Regional Planning Commission statute. There's a companion one of those. I think it's 3.10 for the Municipal Planning Commission. It has all the platting requirements in there. Excellent analysis. All right, let's go on to the next one. Jack Jones, a contractor, is buying a residential building lot in Humboldt. He is getting a mortgage loan from Golden Circle Bank and Trust. Jack's wife, Mildred, is in Destin and doesn't want to come in to sign the deed of trust. Does Mildred have to sign the deed of trust? Why or why not? So, Mike, I think you're first up on this.
All right, so individuals buying a lot. I can't tell. And if is it a purchase money mortgage? I mean, I can't.
It's purchase money mortgage.
Okay, it's a purchase money mortgage. I mean, even though it's residential nature, there's always the possibility of a strange twist of facts where Mildred would be able to claim homestead exemption. But I'm not from a risk analysis point of view, I'm not worried about that. If it's a true purchase money mortgage, and it's where we have a lot of trouble, is that there's purchase money mortgages that qualify, and then there's purchase money mortgages that don't qualify because of the loan that is involved, has things that aren't already on the ground. And that's the problem with a construction loan, is that possibility that would qualify for a purchase money mortgage. With that analysis, I'd say we need to get Mildred's signature on the deed of trust.
You need to get her to sign.
Yes.
Okay. Stuart?
I basically agree, except I think one thing you need to look at is what is the intent of buying it. Is he going to buy to build a house to sell, or is he buying it to build a house for him and his wife? I think you need to kind of look at that issue as well. Okay.
Yeah, it says building lot, so, I mean, I think it comes down to intent, but, yeah, I would probably require her to sign.
I would not. It looks like a purchase money to me. Nothing about her being put on the title with them. Obviously, that would require her signature. So I would not.
No disagreement. I mean, just a couple of things. I want to make sure that we've got the assumption that the lot's only going to be titled in Jack's name. Obviously, anybody that's on title has to sign the deed of trust. And then the other comments are, though, if the title is just in one spouse's name, if it's a purchase money mortgage, then the other spouse would not need to join in for homestead purposes. But as Mike mentioned earlier, I can't quite tell from the question, the caveat is it a purchase money mortgage? I mean, if he's paying cash for the lot and then he's going into giving the mortgage to buy the house, then that may put a different light upon it. But if it's a purchase money mortgage, and if the wife is not vested in title, then I would not require her to sign.
I can't take any different position. As long as it's purchased, excuse me, as long as it's purchased money and the wife's not vested, I'm not going to require it to sign.
Just to clarify, the concern I have is if he's buying a $75,000 unimproved lot, and the mortgage is going to be for $300,000. Then the question is, does that $225,000 is going into materials, supplies, labor to build that? Does that mortgage, is that a purchase money mortgage of the bricks and the lumber that goes on that lot? There's cases that hold that it is not.
Well, great analysis. So I think, who all said that she should sign? Who said she should? Should not. Okay, we have a split decision here. Well, great analysis. You're talking about waiver of homestead, and the question turns on exactly as they said, is it a personal residence? Is it the residence of them, their spouse, or dependent? And also, is it a purchase money mortgage? So get around it either way, but you got a hard analysis that they have really analyzed well. So I guess you got a split decision. Either answer is right.
Yeah. Which office are you running for?
I want
Good comment from the peanut gallery.
Underwriter to give the right.
Good
not
comment.
required to come in.
Good comment from the peanut gallery over here. The lender's going to require them to sign it anyway, so it doesn't matter.
That's probably true. That's the answer. Just have her sign. All right, next question. Kay Howard purchased 5 acres in Goodlettsville subject to this restriction. Quote, no single wide mobile homes. Kay intends to develop the property as a campground and place 16 camper trailers for nightly rental through Airbnb on the property. She wants an ALTA 3406 endorsement. I learned that yesterday, by the way. Providing affirmative coverage that she can do this on her owner's policy. Will you provide the coverage? An agent for a competitor, Boathouse Title in Hendersonville, has already said they would issue the ALTA 3406 endorsement. So, Stuart, I think you're first up.
I don't remember what the 34 is, because that's not one of the
Mark.
Basically, it's affirmative coverage over an identifiable risk.
Yeah, 'cause we always do that in the body of the policy itself. Oh, wow, it's a hard one. I think I would decline it because it really, I think it would depend on what the definition of how you define what a mobile home is. And if those camper trailers are there permanently, I don't think that, I think that would be a violation of the restriction. So I think I would decline to give the coverage.
Justin, what do you think?
I mean, in order to give that coverage, I would probably require all of the lot owners subject to this restriction to sign something saying that they can do this. Because I agree. I mean, I think the single wide mobile home and then 16 camper trailers, it's too close to, would be for my company.
This makes me think of a lot of other considerations when you're underwriting. You know, your agent, there's a business decision here, not just risk decision. And some of the risk decisions I see are, they've already addressed them. I would say, okay, agent, tell me about the rest of the property renter. Tell me where this restriction came from. Where does it start in the chain? Who imposed it? How long ago? What about around it? Are there mobile homes all around it now? And this was 50 years old. You know, there's things like that I could ask. I'd certainly, you know, depending on the answers I got to that, I would want to know about approaching neighboring properties to see if they would be willing to, appropriate and willing to do something saying they weren't going to enforce that. The business decisions would be, I mean, I guess when I saw the part about the competitor being willing to do it, you know, and if I've got a really good agent that sends me a lot of money, is that wrong to say? You know, I might say, okay, well, and we know, let's say Boathouse Title is reputable and they're not trying to just steal the deal. They really feel like that their underwriter said it's okay. There's a lot more for me to consider here. I mean, just before I would say just no. I mean, I'm inclined to say no just from the question that we have here, but it brings up a lot of thoughts about not just risk but business practices and what I would like to be able to do for an agent depending on the circumstances.
So kind of a maybe.
Kind of a maybe. Definitely something to look into and talk about more.
Lost for words?
Yeah, I would have a hard time getting comfortable with this one. You know, theoretically, if you went back and found that the restrictions were just applicable to this tract, and as Tom mentioned, you might look into whether there was an opportunity to get a waiver and so forth. But this looks to me like the classic example that you hear of, well, you know you would win the lawsuit. Well, you know, we only get one premium. And yeah, you might actually win the lawsuit. But just on the surface, I mean, this goes so against what appears to be the intent of the restriction. So Tom made a good analysis. I mean, if you look, and this property was surrounded by, you know, mobile home parks, and the restrictions only applied to this particular tract, yeah, maybe. But I mean, I'm going to go into this one saying, I'll look at anything you want to send me, but I don't think you're going to convince me. You've got a big burden of proof on this one.
So Boathouse Title is going to be issuing that.
Yeah, most likely.
Well, my first question is, who's Boathouse's underwriter? Because so far everybody said pretty much no up here, so it makes me think they haven't asked their underwriter. So
You have agents that do that too?
oh yes.
This one.
So, you know, and I think the analysis was made because you look, the restrictions on this 5 acres. Existing only 5 acres that was ever burdened by this restriction. Does the seller own other property around this? Is she trying to prohibit having a single wide next to her property? Who's benefited from this restriction? So you got to look at that. Is a camper a mobile home? It's got wheels, it's got a title. I mean, but there are specific manufactured housing statutes that define what a mobile home is. Campers are not in that stat. They have titles to it, but they're still not in that statute. But again, if you're going to get down to the argument of it, the defense cost is going to far outweigh the premium you're going to get from this transaction. So, without consent, being able to get that restriction removed, no.
And I say to the beneficiaries of the restriction, what's the difference between a 38-foot fifth wheeler and a 40-foot mobile home, single wide? You know, very little difference. So, just as Tom said, the way this is another classic example of the difference between where we're not lawyers when we look at this question. We're title insurance underwriters. It's risk assessment, and that's the question is assessing the risk, and then the question is with that risk assessment. But I think Tom, like Mark, it's looking at and assessing that risk. What's the story behind the restriction, and who are the beneficiaries of that restriction?
I would say that a turning point for me on this is I agree that those are not included in the statute of what defines a mobile home. But they're going to be, it just implies that they're going to be placed in the property permit. And that's the difference for me.
It sounds like our, who's issuing this contract? We don't know, he was. You're going to have a hard time getting title insurance if you call your underwriter on this one. Well, I think that's the right answer, and the Court of Appeals of Tennessee, in the case of Granger County, exactly square on these facts, agreed. It said that this 16 camper trailers being rented in a campground on the property does violate this restriction, even though you can define it, but whether the definition of a single wide is, they said it violated this restriction. Case of Napier versus Howard, July 25th, 1916, Eastern Section. So, I think our underwriters have called it right on the money on this one, and our Court of Appeals has said the same thing.
None of you guys talk about the Airbnb part of
None of us up here know what Airbnb is.
You're not sure
Airbnb is like a nightly, I mean, it's basically turning these things into separate hotel rooms. It's a nightly or weekly or, you know, some sort of short-term rental, internet-based rental. And the description doesn't say anything about, you know, rentals on the property. So that's why I didn't really see it as any part of the thought it was just a,
Well, no, excuse me, we would not, the Alpha 34 would not insure the use of at the Airbnb. The Alpha 34 would only ensure that the camping trailers did not constitute a single wide, mobile home and violate the restriction. We're not going to get into the air snub use or whatever.
Now, the 3406, what it really says is that you're going to insure over during the law as a result of that, a violation of that restriction.
Right.
Single out, and I heard several of them mention talking about defense costs. But under the 3406, the 3406 says we'll insure against the violation of that after a final ruling of a court of competent jurisdiction. Something like
Yeah, but it also
exactly, Gene. And when we were talking about this yesterday, someone over here was talking about it and said, well, it's on the limited coverage. And that's true, but that was, the question was that, I mean, again, the issue is, are they gonna get it at all? And yes, if they get it, it's not the same coverage as if that restriction were, deleted.
But the end of the ALTA also covers defense costs in the 34. Yeah, on down, and yeah, I don't have it in front of me, but
That's a substantially broader
yes,
than a practical application.
absolutely. You know, where we've said just against a, decree from a court of competent jurisdiction of last resort. So the ALTA 34 is broader. Yeah.
Any other questions?
What?
I always, when I go to a seminar, I look for one thing that I can take away that I didn't know about before. You know what it's going to be on this seminar? Right. We're going to start seeing those everywhere. So, okay. Any other comments before we leave? Okay, next question. The deed to the Overton's residence in an active adult community was signed in 2007 as follows. Pull-Tight Homes Corporation, an Indiana corporation, by Grayson Fulton, President. Title was actually vested in an affiliate company, Pull-Tight Residential Partners Limited Partnership, an Indiana limited partnership, whose general partner is Pull-Tight Homes Corporation, an Indiana corporation. An application to ensure a sale of the property has been received. What do you advise? Justin, I think you're first up.
Well, I haven't played this card yet, so I agree with Mark Rosser. I was told that's all I had to say in this panel. So,
Son, you're going to have a long career if you're
what do I would actually advise a quitclaim deed from the actual limited partnership with a deed that actually vested from the actual owner of the company. What I would advise. General partner is I'd have to see. I'd probably see the deed, but that's probably what I would do. I'd probably require a quitclaim deed from the actual owner, from the named owner.
So you'd require a quick claim
From the limited partners, from the LP. Right.
Well, that's definitely been incorrectly executed. But I would ask my agent first, does your owner, seller, borrower have an owner's policy? Because they just get a letter of indemnity or something. I don't think the MIA would cover that, but letter of indemnity, I think I'd term it more like a corrective deed so that it related back to 2007, but I agree with Justin about needing to get that fixed if you can't get an indemnification over it.
So indemnification from the other underwriter would be adequate.
I think the first place I would look is the front of the deed. Now, if the deed itself states that it's from the limited partnership and has the appropriate grantor and goes down it, then what you've got is really almost akin to a typo by not putting that above the signature line and so forth. I would obviously want an indemnity. I would want to look, if I could get it, I would look at what had happened in the chain of title since 2007. If the deed itself said it was from the corporation rather than the limited partnership, then I would want corrective measure. But if the deed itself said it was from the limited partnership, and you've got that technical execution issue where you've got the general partner signing, but the appropriate status wasn't listed, I could probably, that's one of the rare cases, I hate to say Scrivener's affidavit, but there would be more options there to continue insuring it. But it goes back to how does the original deed, who is the grantor in the deed?
I agree with the grantor. If the grantor is listed correctly, when you boil down to it, your corporation is the general partner. The president of the corporation is signed it. Now, do we have authority documents that show that we have the authority to sign on the corporation? No. But obviously the intent was there to convey it by this entity. Now, best case scenario, I want a correction deed. Quick one, be a correction deed. We haven't discussed whether it's even possible to get one. Is the corporation still around? I'm going to first say, go get a correction deed. Get this corrected. Why not get it done right now where you're doing this instead of pushing this thing down the road? Now, if the corporation's gone, all the entities are gone, obviously you can't get there. Then what am I looking at? Well, the worst case scenario I'm looking at is possibly getting a court to do a reformation action on that deed.
Mike, are you sure you wouldn't take a scrivener's affidavit?
Well, if I can get the deed first, yes. If I can't get the deed, I might take a scrivener's aff. But I'm going to start with the more conservative approach and then come to that. And then again, if I do the investigation and find the entity is gone, I'm not going to be able to get anything. Maybe a scrivener's affidavit, maybe an affidavit in furtherance of title. But
your answer is getting better.
But yeah, I think so too. But when I'm looking, what's the worst case scenario I'm looking at? I'm looking at a reformation action, probably the worst thing I'm looking at.
I guess what I do is I suggest the Overtons contact you, retain you to get this matter resolved. Because I think it's a bit of a problem. It's a marketability issue. I don't think the scrivener's affidavit, which is statutorily authorized to be recorded, can cure something that is a serious, significant defect. It's this. Again, that's with all the caveats. Show us the deed. Let us see the four corners of the deed, as opposed to just see who signed it. Who did the notary acknowledge? So I think it needs to be fixed. I think there's different ways that need to be fixed, and I think that lastly, again, as I think everybody's brought up here, looking at the whole document, you may not need to do anything. It may be insurable as is.
Basically, I would start out with the asking for a deed of correction. I'm okay with, if that's not possible, I'm okay with the scrivener's affidavit. I think one issue, depending on how recent this is, one issue is you might want to look into the authority documents of the limited partnership and see if Grace and Fulton had the authority to sign as the president of the corporation on behalf of the limited partnership. But as a general rule, my first thing I would ask for would be a corrective deed. If that's not possible, I'd be okay with the scrivener's affidavit.
Stuart, I really like your answer. So we're going to go with the Great analysis. Do you ever see this kind of thing? All the time. It's like Joe just said to me, I wonder how many deeds were done like that. Probably a whole subdivision full of them. So we see this kind of stuff a lot. Mm-hmm. Good answers, good analysis. Excellent analysis. Exactly. And there's a state tax lien to boot. That's next year. We'll put that on. Okay. All right, great answers. All right, next question. Wind Farm Title closed a conventional loan for ABC Lending Group. Closing instructions required that Wind Farm's principal, Rhonda Rafer, be designated as trustee of the deed of trust. Rhonda conducts the closing and notarizes the deed of trust. Will you insure the deed of trust? Why or why not? Tom, I believe you're first up now.
Do we have a few minutes to confirm?
No, that would be an antitrust violation.
I don't know how you planned this since we sat down randomly and I was gonna be the sixth person. Maybe you could. You know what? I see what's going on here, but it's all conventional. Nobody's trying to be nefarious. I think I would insure it.
So what do you see as the issue here?
She's notarized, well, I mean, it's a conveyance to her of the legal title. And she's notarizing the signature of the person who's mortgaged the property. So that's what I see is, but it's not like the deed to the grantee and the grantee's the notary. You know, there's no reason to call into question the actions of the notary here, that she's violated her fiduciary obligations to notarize properly. She's just acting as the trustee, which, you know, that's the issue, I know, but, you know, would you insure it? I suppose, you know, the other answer would be, well, it's just got done, just make them redo it. But no, I'd say yes, because I don't see the. All of a sudden, I thought of the words bankruptcy trustee.
So you would say, okay.
Well, you know, I'm going to change my answer because I thought of a bankruptcy trustee who would use that to set aside the deed of trust. So,
Okay,
no.
So you would say no.
Change my answer, yeah.
Mark, you're up.
You know, this is one that I don't think the court is going to invalidate the trustee. Okay? Because the borrowers received consideration, and they're not going to set aside the trustee. Having said that, I think Tom is absolutely correct. If I have this on the front end, I'd like to see it go ahead and get it fixed, because I just don't want to pay to win that lawsuit, which I think we would win. Now, sometimes you all can correct me, but sometimes I understand that agencies lag behind a few months in issuing policies. I know that wouldn't be the case with anybody in here. So, I mean, you know, I'm saying, so, you know, once more, if it's been several months before this is found, there may be extenuating circumstances. I don't think this renders the trustee void, but from a prudent underwriting practice, I would want it fixed just to alleviate the problem, alleviate arguing with the bankruptcy trustee, or having to win the lawsuit that I'm pretty sure I would win.
My first thought is that there's multiple deeds of trust sitting out there that are just like this. Because how many small closing shops is the person listed as the trustee that's also the notary in the office? And I'll take it a step further than that. If that becomes an issue, you've got the power to appoint a substitute trustee inside the deed of trust. Why can't you just appoint a substitute trustee and cure the problem? Because if the lender appoints a substitute trustee, they're eliminating that issue. I don't think it's an issue. I think I would insure it without having a problem with it.
Okay. Mike?
Well, I think it's an issue. It's an issue because Wes put it up here. I think the general, and I always look at the general rules. The general rules is it's an issue. It's problematic anytime a party to the transaction and the notary that takes the acknowledgement is the same person. Where in this case, the grantee and the notary is the same person. Now, having said that, that's with my lawyer hat. I need to have a white one and my lawyer hat and my underwriter hat. But having said that, I think that often marketplace considerations come in, and that we can move on with it. But I think it is an issue.
I can honestly say that in 30 years, I've never seen this particular issue come up. So I'm not real sure, but I think I go with Mark's answer. I'd be concerned about it because you have the person taking title to the property as the trustee is also notarizing the signature, and that's a little bit concerning. And then when you go, if there is a bankruptcy situation, I tend to think that the trustee could have it set aside. I mean, the bankruptcy trustee. So I think I would decline to insure that.
Yeah, I think as Mark said, it comes down to the fixability of the problem. If it's, we have a saying, when I talk to our other underwriters, we commonly ask each other this questions is, did you crush any dreams today? And this may be one that, because I tend to agree. I mean, again, there may be nothing wrong with it, but it's kind of like as the Bible says, shun the very appearance of evil. And I think that you could potentially have some self-dealing stuff here. You don't know. Again, like I said, I don't think I've ever seen this or had this ever brought to my attention this issue. But I could certainly see where there are deeds of trust of record out there where this is the case. But I'm interested in what the court said. So,
well, we don't have a judicial decision. However, we have a decision by the Honorable Eugene McCullough in our Principles of Title Insurance, which you can purchase through raised edition. See Lisa at the table. On page 462 of the 2014 edition, section 45.8.6 says this: one who is a party to an instrument, no matter how small or nominal therein, cannot act as a notary public on the instrument. So, buy our book, that's what it says.
True confession. Believe it or not, once upon a time I was a younger man, and when I was practicing, and I can remember one of the, at that time, older title folks coming over to me once at the courthouse, kind of put his arm around me, and he said, "Mark, why did you notarize your own appointment as successor trustee on this transaction?" I did the very thing. Felt like an absolute idiot. Still to this day don't know why I did. Obviously we had to get it fixed, but it does happen.
Well, it happens to the best of us. All right, next question. Ellis Hunter is a resident of NHC Gallatin Assisted Living. His former neighbor, Ford Jackson, handles Ellis's financial affairs through a durable general power of attorney. Ford contracted to sell Ellis's former residence as attorney in fact. Ford also signed the deed and sale closing documents as attorney in fact. The day after closing, but before the deed is recorded, Ford and the closing attorney learned that Ellis died the day before closing. What should be done? I guess, Mark, you're up.
Well, I would say dig him up, but I don't think he's been buried yet. So, yeah, we have a statute that says that if the property owner executed a sales contract and then dies before it's consummated, that then the personal representative can execute the deed. Now, it doesn't specifically address execution of the contract by attorney in fact, but probably in that case, I would do a couple of things. One, just in order to protect the record, surprisingly enough, I would tell them to go ahead and record the deed, because I would want something of record protecting the buyer. Then I would want an estate opened, a personal representative appointed, and then the personal representative would execute another deed. I don't know if I'd call it correction deed or whatever else, and also record that.
Well, I agree with the personal representative. I think, once the death occurred, the power of attorney ceased. Now, the question becomes, though, were they aware? Now, obviously, they weren't aware at the time of the execution of the documents that he was dead. So, I think, if I remember correctly, the statute talks about if parties are unaware and the document's executed, then it's a validly executed document. So, but how do you know if they were aware or not? I'm underwriting the risk that they did not aware. They're telling me they didn't know, but how to know? So, am I going to protect myself by asking the personal representative to get a deed and sign it later, get the deed recorded, then just have that as an ounce of caution? I think I would. I think it's hard to determine who knew what when in this situation. And so, they could tell me that they didn't know, but maybe they did. I don't know. But who's going to be able to establish who did know what?
So you're suspicious.
Yeah.
I would like to require, again, take the belt and suspenders approach. Why? It should be easy. This is all, it's fresh. This is not something that happened 25 years ago or even 5 years ago. We have, again, we talked about yesterday, when does title vest in the devotees and are the heirs? Immediately. So again, for marketability or insurability, rather than trying to find out what the precise legal reason is, I would say, look, let's go ahead and get those heirs and the PR if we need to, because there's so many other issues, as we talked about yesterday. Who's the D2? Is the D2 one of the kids? Is there a fair market value? Is it a $75,000 sale, or is it a $750,000 sale? So it's all those other facts. But as a general rule, I'd say if we have an opportunity, let's put the suspenders on to go along with the belt.
I would say that, assuming they did not know that he had died, I think the power of attorney is still good. I think the conveyance is good. But I would go along with getting the personal representative to sign a new deed. But I think to do that, I would ask for an order from the probate judge allowing that to continue.
What if let me ask you a question on that. What if there was no will?
You've got an executory contract. Executory contract's already taken title out of the heirs. I mean, it's vested the real title already for practical purposes. So the court, it doesn't matter whether there's a will or not. The court, once they appoint the personal representative, the executory contract, personal property now. So they're going to have control of the personal property just via the statute anyway.
I agree with that.
Yeah, this is just a case of there's too many questions out there that we don't know, and when there's lots of questions, that usually leads to somebody getting mad about and filing a lawsuit. So I agree. I would have a personal representative. I would have it go through the if it's intestate process. Personal representative sign a deed.
I'm going to be different. I'm going to rely on the statute that Mike mentioned, and I would get an affidavit under penalty of perjury that we didn't know the guy had died. It's a valid deed. You get that affidavit. The statute says you're safe. That's where I'd come down on it.
Okay. Well, that's a good place because Tennessee Code Annotated, Section 346105 says, the death of a principal who has executed a written power of attorney does not revoke or terminate the agency as to the attorney in fact, who without knowledge of the death of the principal acts in good faith under the power. Any action so taken binds successors in interest of the person.
It talks about getting an affidavit or something to shore that up. No? Well, that's what I would do.
I'd have to be retained to answer that. you wanna know the answer, call me tomorrow.
Well, that's what I've required before.
Won't make any difference. It's an executory contract. It occurred before the death. TNTLA won't come into play.
Right.
Since there's an executory contract, that property cannot be subject because it's never going to come into the estate. Can't be brought in the estate even if it's insolvent.
It goes out.
Okay, next question. Larissa Sapp filed Chapter 7 bankruptcy in the Western District of Tennessee. Prior to filing, Highway 45 Rentals filed a $50,000 judgment lien against Larissa, which attached to her personal residence. Larissa's Chapter 7 ran its course. She received a discharge in bankruptcy, and her case was closed. A title insurance commitment has been issued for sale of Larissa's house, which does not show the pre-bankruptcy deed of trust and judgment liens as exceptions. It's your advice. Mike, I believe you're up.
The commitment is wrong. The judgments aren't gone because the discharge doesn't wipe out the lien because the discharge is just an in personam injunction. The lien itself is just an in rem action. And if you look at the bankruptcy code, it only creates an injunction against actions against the person. So the lien survives. Now, the only way, you did mention it's a principal residence, but you got a $50,000 judgment. So the only exemption we have in the state of Tennessee is the homestead exemption. So technically, the homestead exemption limits the dollar amount, which there's discussion of whether that $50,000 could be, even if you avoided the lien through the bankruptcy, which you could, pursuant to 522F of the bankruptcy code. But can you avoid the whole thing? Because the homestead exemption has a specific dollar amount. So are you limited to that? And could you wipe out the 50,000 judgment or not?
What do you think, Mike?
I agree. It's the same thing. I mean, this is one of the very common things that we see. And the only thing I want to confirm is to look at that bankruptcy file. It doesn't happen very often, but sometimes for whatever reasons, the bankruptcy court can affect the liens.
I don't claim to be a bankruptcy expert. My understanding is that for the liens to not apply to the property, they would have to have been specifically discharged. Just a general discharge, I don't think, if I'm not mistaken, will cover that. I would require that they be released as to the property.
Yeah, I mean, the rule of thumb, lean in, lean out. So if it's a lien going in, I would require that they be released. I agree. I think the commitment is wrong. At least you gotta show them. I do agree. I think there's some homestead issues there, but on the judgment lien, as to the judgment lien, but Highway 45 Rentals. Okay, it's against your personal residence. Yeah. So, but yeah, there we go. I think everybody said everything I could say.
I think it was Derry Jackson that taught me this. It told me how to say it. It's what Mike Davis said, but it's easier to grasp, certainly when you're trying to explain this to a realtor or to Larissa, who's wondering why, that she no longer owes this debt, but her property still does. That seems to help. They say, oh, I think I can sell it that way. Because they'll argue with you about it until you figure out how to explain it.
Yeah, I would just mention, everybody's alluded to it. Liens do not disappear unless the bankruptcy court specifically says that the liens disappear. And there might be reasons for that. The lien might be a preference, for instance. But even if it's an obvious preference, it doesn't disappear on its own. The bankruptcy court has to issue an order removing the lien for whatever reason. Now, we'll add too, and I got mad because it didn't help a bit. Somebody mentioned earlier, I've actually seen an order. This may have actually come from Arkansas. I can't remember. You know how those folks are in Arkansas. Where you had a similar situation, and the bankruptcy court removed the lien to the extent that it impacted the homestead interest. Well, what does that do for me? You know, it didn't say to what extent. And, you know, and you mentioned that earlier. So then we're still left in the same boat. And the other thing, that was a great analogy from Derry, but I mentioned to people too, they'll talk about judgment liens. I say, look, if that judgment lien is recorded before the person files bankruptcy, look at it as a mortgage. You know, the mortgage doesn't go away because they filed bankruptcy. If they did, no lender would ever loan money. And so once that lien is recorded, as you said, lien in, lien out. So, yeah, they have to be taken care of.
So you start mine.
Yeah.
Well, good answer. So, I guess lean in, lean out. She doesn't know the debt, but the property does. Good word from you. Okay, we're going to skip over a couple because I've got one I really want to know the answer to. We don't have much time. Now, this one's about Chamberlain here. 12 South Ventures is selling its 12-tenant strip shopping center in Nashville. Longtime tenant Earthworks Organics has just renewed its lease and is well into the remodeling required by the lease renewal. But the buyer demands that you issue a commitment and pro forma policy without exception for mechanics and materialman's liens. There are no other construction activities on the property. How do you respond? I guess, Mike, you're up. Mike Bates.
Commercial property, landlord tenant, mechanics materialman's lien. The lien can only attach, if there is a lien, a claimable lien, can only attach to the estate that contracted for the work and the materials. So it can only attach to the tenant's estate unless there is a contractual provision to the contrary.
Yeah, I agree with that. I mean, you can only, a lien, a mechanics lien against a tenant will not affect the fee unless there's some agreement between the lessor and the lessee that the lessor will take some responsibility there, but otherwise it would not affect the fee. So I would not have a problem, unless we have some additional information, I wouldn't have a problem with issuing the commitment and pro forma without the exception.
Yeah, I'm thinking, is some new guy, do I get a pass yet on any of these? These guys are, I was going to say, use a word I shouldn't use. These guys are much wiser than me. They've been around a lot longer, so. But I seem to remember. Maybe I remember this from law school. I don't think I've ever come across this issue where somebody's asked for mechanics liens from the work done by a lessee. But I think those attaches to the property, the material at least, and the work. I thought it would attach to property. I would probably require and I could be wrong on this. So I would probably require some financials and an indemnity from the contractor before I would issue some mechanics liens coverage.
I just actually got around here where I can see this, and I want to amend my statement. I think the phrase required by the lease renewal is significant.
Oh, come on, you just jumped the gun on me. I was going to say that. We're talking about there being no contractual relationship, but I'm not really agreeing with that. If there's remodeling required in the lease, that contractor could be a beneficiary of those. If the tenant's got to do this stuff under the terms of his lease, and he's got to go out and hire people, and I think by extension, he is able, or the liens can reach the fee because of that. So, you know, when I first read it, I thought, it's going to take some doing to give them what they want. You know, who's the contractor? What's his reputation? Financials? All those things. That's where I'm.
I would also think that if you have a situation like that, you probably ought to ask for a copy of the lease so we can see if the lease there.
What do you think, Mark?
Yeah, there's a couple of things. One, our position would be if the lease requires the remodeling, then it's going to attach to the fee, at least to the fee portion encumbered by the lease. And here's something else too. And I'll be careful how I say this. I'm not trying to kill the deal, but the buyer's benefiting from all this. I mean, if you forget the sale transaction for a minute, you would not insure the current owner as to this work, because the current owner is requiring it under the lease, and it's work that's benefiting the current owner. Now, the buyer is stepping into that. The buyer is benefiting from these leasehold improvements. So I think, you know, what we would do is we would analyze it in terms of, you know, it said this is the only construction on the property, so maybe these tenant premises are just a small portion of the overall value. We could probably craft some coverage that would protect the buyer's lender. Okay, that would enable the transaction to go forward. I don't know if we'd need an Alpha 32, but I think we could work on that. But I would be hard pressed to want to give the buyer protection on improvements that are inuring to the buyer's benefit and continuing after the buyer. You know, maybe you come up with something where you're making sure that any protection was just as of the date of the policy, and you're not protecting the buyer from some sort of file back or whatever. It gets kind of complicated. But I think we could protect the lender. We'd have to go through some curves, but we would start off with the premise that it would attach to the fee portion, at least the fee portion subject to the lease.
Mike?
When I see the word required, I think back, you know, all the cases on this issue center on control and cash. Does the landlord have control over the work that's being done, and are they providing money for the work that's being done? Now, we don't know the terms of the lease here, so we can only speculate. But when I say required, that signals to me control. So I think I would start off with the position that yes, this is going to attach. Now, are there things that we can do to work around it and to limit the risk and craft some things? Yes, there probably are. Most likely we've got one contractor that's doing all the work on this. Can we get bonds? Can we get a performance bond put down that's going to cover the cost of that whole contract, which will eliminate any possibility of liens attaching? So we look at our options. Right now we don't know what our options are because we don't know what the terms of that lease are to know what we need to craft. But I think we can craft things to make it work.
I'm glad you said the same thing you did the last time I asked you this question. Well, Tennessee Code Annotated, Section 6611-102D, which is in the mechanics lien statutes, basically does focus in on that word required, because the question is does this situation make the tenant an agent of the landlord? And if it does, then it can attach to the landlord's interest through a series of factors you looked at there. So the analysis, I think, is very timely for everyone on the panel. Okay, we're about out of time. I want to get one last question. We're going to have a lightning round on it. So let me go to that. Okay, last question. A real estate investor acquired a warranty deed earlier this year to several thousand acres of timberland on the Cumberland Plateau. The title search and examination show an unbroken chain of title back to grants from the state of Tennessee in the 1850s. The investor's grantor had been deeded the property in 1972. The grantor said he had not been on the property since 1972 when he thought he saw part of it from the highway. The investor wants a title insurance policy ensuring his ownership. How do you respond? And I think, who's up next? Stuart, you're up. Quick, we're going to have a lightning round on this.
Man, I'd say he's had it since 1972, even though he hasn't actually seen the property. If he's got a recorded deed, you know, he's got ownership, but I don't have a problem with insuring that based on those facts.
What do you think, Justin? You're the new man.
So I am. So I was make sure I understand what's going on here. Okay, you're going too fast for me, man. Slow down.
You got 30 seconds.
30 seconds. Dun, 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 dun. So he got it. The investor's grantor had been deeded in 72, that's who he got the deed from just now. From this guy. He had a deed. I don't understand. What issue am I missing here? Several thousand acres, huh? That he had never seen. Is he seized? Did somebody pick up dirt from the ground and drop it in his hand? Yeah, I think I'm with these guys.
Great answer. Tom, what do you say?
Good.
Says nothing about a new legal or survey. I'm gonna assume a survey got done. Maybe. Okay. Well, yeah, I will insure it, but that policy is going to have all kinds of the parties in possession and survey. He's got good title, you know, but the exceptions in that owner's policy are going to cover all these things that crop up when you're talking about property that the owner's never even been on and hadn't seen. And just as long as you got a good legal description, you got your chain of title, you can insure that. But there's a lot of stuff that they aren't going to be insured on.
Okay, Mark. Mark, put this thing to bed.
West, you ought to be ashamed of yourself. But the interesting thing is, and this is Wes's annual or semi-annual Champerty question because of not being in possession for all that length of time. Interesting, and I'm asking this. My answer will be no, but I'm asking honestly. I would have to do some research. I'm not sure how I would fix this. That's the troubling thing to me. But no, I wouldn't insure a deed just on its face from the fee owner.
So here, I mean, you don't know what's happened since 72 out there. And I'm just not going to touch that. You know, we don't know. There's just so many unanswered questions without doing some investigation. Now, if I do some due diligence and I find I can get comfortable with it, maybe, but not just based on the facts.
When they told me they did a 160-year search, I knew they were lying.
Well, I got to say, this is the Champerty question. If you want to know about Champerty, ask Mitchell Ross. If you're not in possession, what happens if you're not in possession for the last year? Deed is void. So that's TCA 66-4202. So
Legislative committee, it's gotta go.
listen, that makes the seminar. Let's give these guys a hand.